As of December 1st, 2023, Phase 2 of the Trust in Real Estate Services Act will come into play, and this will replace some of the rules from the Real Estate Business Brokers Act of 2002. Part of those new rules will be the seller's decision on what they would like to reveal, if anything, when it comes to an offer presentation, designated agency where a brokerage can represent more than one client at the same time, and what we will go through today, which is a RECO information guide on working with a real estate agent. This is a mandatory guide for all buyers, sellers, landlords, and tenants moving forward from December 1st, 2023. So if we've connected, you've received a copy of this booklet either digitally or in person. The purpose of this video is to go through each page of the guide, to go through every single element when it comes to the RECO information guide. This is a guide titled Working with a Real Estate Agent, Things You Need to Know. It's provided by the Real Estate Council of Ontario, and we will go through each page one by one. The Real Estate Council of Ontario regulates real estate agents, brokerages, educates consumers, promotes a fair, safe, and informed real estate marketplace. RECO administers and enforces the Trust in Real Estate Services Act 2002. You can find out more information on the RECO website, reco.on.ca. About this guide, you have received this guide from Real Estate Agent because you are considering receiving services from the real estate agent, or the agent is representing a client in the transaction, and you might receive assistance from the agent. Real estate agents in Ontario are required to walk you through this guide before providing services or assistance to you. Please read the guide carefully and talk to the agent if you have any questions. In this guide, a brokerage means a real estate brokerage. Real estate agent and agent mean a real estate agent, and agent mean a real estate salesperson or broker. You and client mean a buyer or seller. Buyer and seller can also mean leasee and leaseor respectively. As noted, this guide is for buyers, sellers, landlords, and tenants. What is inside the guide? Working with a real estate agent. Page 2 section will describe the benefits of working with a real estate agent, what you can expect, and the responsibilities of clients. Know the risks of representing yourself. Page 4, this section explains the risk if you choose not to work with a real estate agent, and the risks of receiving assistance from a real estate agent who is working for the person on the other side of the transaction. Signing a contract with the real estate brokerage on page 6. When you work with a real estate agent, you sign a contract with the brokerage the agent works for. These contracts are called representation agreements. This section highlights what you should look for before you sign. Caution, multiple representation not permitted unless you agree. That's on page 9. Multiple representation means the brokerage or the agent represents more than one client in the same transaction. This section explains how multiple representation works and what to expect if you agree. And page 11, how to file a complaint. Ontario brokerages and real estate agents are accountable for their conduct. This section tells you how to raise a concern with the brokerage and with RECO. Legal disclaimer, the content of the RECO information guide is intended to help buyers and sellers make informed decisions. This guide is not intended to act as a substitute for legal advice or as a replacement for the Trust in Real Estate Services Act 2002. Readers are encouraged to retain qualified and independent legal counsel to answer any legal questions or address any legal issues. Where there is any discrepancy, the legislation will take precedent. Working with a real estate agent. Agents in Ontario must be registered, which requires completing the necessary education and carrying consumer deposit insurance and professional liability insurance. Real estate agents provide valuable information, advice, and guidance to buyers and sellers as they navigate the complexities of real estate transactions. As we go through this document, we will go through both the seller and the buyer sides. If you're a seller, an agent can advise you on market conditions and the best strategy to attract buyers and get the best price for your home. Market or advertise your home, including arranging photographs, videos, and virtual tours. Provide referrals to other professionals you'll need, like a lawyer or home staging company. Arrange and attend home inspections and appraisals. Arrange showings for interested buyers. Advise you on how to handle competing offers, sharing the content of competing offers and other aspects of the transaction. Vet offers and potential buyers to ensure they can afford to buy your property. Negotiate with buyers to achieve the best results, price, and terms for you, and guide you through the paperwork and closing the transaction successfully. If you're a buyer, an agent can assist you with getting pre-approvals for financing so you know how much you can afford, make you aware of any tax exemptions you might be eligible for, gather and share information about neighborhoods and homes that meet your requirements, and arrange to show you homes you'd like to see, make inquiries about zoning, permitted property use, and other aspects of the home, advise you on the best approach in competing offer situations and how to protect protect your offer information. This will be new and something we discuss in further videos about the new offer situation rules. Negotiate with sellers to achieve the best results, price, and terms for you. Guide you through paperwork and closing the transaction successfully. Provide referrals to other professionals you'll need, for example, home inspectors, lawyers, or contractors. On page 3, you will also benefit from the duties and protected by the brokerage or agent representing you. As a client, your interests take priority over the interests of the brokerage, its agents, and any other party. Disclosure. They must tell you everything they know about the transaction or your client relationship that could have an impact on any decisions you make. Confidentiality. Your confidential information cannot be shared with anyone outside of the brokerage without your written consent, except where required by law, even after your client relationship ends. This includes, for example, your motivation for buying or selling and the amount you would be willing to pay or accept. Avoid conflicts of interest. They must avoid any situation that would affect their duty to act in your best interest. If a conflict arises, they must disclose it to you and cannot provide any additional services to you unless you agree in writing to continue receiving services. You have responsibilities as a client. You need to be clear about what you want and don't want and make sure you share all information that might be relevant. For example, you might want zoning that permits your intended use, maybe a home office or another specific use, or you might not want a property where there has been a violent crime. Respond to agents' questions quickly. Understand the terms of your agreement with the brokerage and pay the fees you have agreed on, which we will discuss on page 7, even if an agreement to buy or sell later falls through because of your default or neglect. On page 4, know the risks of representing yourself. If you're involved in a real estate transaction and are not a client of a real estate brokerage, you're considered a self-represented party. This means that you have chosen to represent yourself, which has different rights and responsibilities. Very few buyers or sellers make this choice. There are significant risks to representing yourself in a real estate transaction if you do not believe you have the knowledge and expertise required to navigate the transaction on your own. You'll be dealing with a seller or buyer who is benefiting from the services, opinions, and advice of an experienced real estate agent. The Real Estate Council of Ontario recommends that you seek independent professional advice before you proceed as a self-represented party. If you choose not to work with a real estate agent, it will be your responsibility to look after your own best interests and protect yourself. This may include things like making inquiries about zoning, permitted property use, and any other aspect of the property, determining what you believe to be the value of the property you are buying or selling, determining how much you are willing to offer or accept, competing offer situations, deciding what terms you want to include in an offer or agreement of purchase and sale, and preparing all documents. The real estate agent is working for another party in the transaction. It's important to be aware that the agent has a legal obligation to act in the best interests of the person on the other side of the transaction. If you are a buyer or even just inquiring about the property, for example, and the agent is working for the seller, the agent has a duty to do what's best for their seller client. Be aware that the agent is obligated to share anything you tell them with their client, which might not be in your best interest to tell them, including your motivation for buying or selling the property, the minimum or maximum price you are willing to offer or accept, and your preferred terms or conditions for an agreement of purchase and sale. It continues to say the agent cannot provide you with any services, opinions, or advice, do anything that would encourage you to rely on their knowledge, skill, or judgment, or encourage you to represent yourself or discourage you from working with another real estate agent or brokerage. Any assistance they do is in the best interest of their client, not to you, and is to help their client sell or buy a property. The agent must give you RECO's information and disclosure to self-represented party form and walk you through it before they can provide you any assistance. You will be asked to confirm you received it and understand what it means to be a self-represented party. This is a different document than the one we're currently going through. You have the right to change your mind. If you're concerned about completing a transaction on your own or you need advice from a real estate agent, you can choose to become a client of a real estate brokerage at any point during the transaction. See signing a contract with a real estate brokerage on page 6. Signing a contract with a real estate brokerage. When you become a client, you sign a representation agreement with the brokerage, a contract between you and the brokerage for real estate services and representation. If you don't want to sign an agreement, you should not expect the real estate agent to provide you with any services like showing you home. Representation agreements can be called buyer representation agreements or seller representation or listing agreement. Your agreement must be put in writing and presented to you as soon as possible. Protect yourself by reviewing the agreement in detail. This will help to avoid any misunderstandings between you and your real estate agent. There are two kinds of representation agreements in Ontario. Brokerage representation. The brokerage and its agents represent you and must promote and protect your best interests. But one of the brokerage's real estate agents may be your primary contact. They may provide referrals to other professionals you'll need, for example, home inspectors, solicitors, lawyers, contractors. The other type of representation agreement in Ontario is designated representation. One or more of the brokerage's real estate agents is your designated representative. The agent represents you and must promote and protect your best interests. The brokerage and its other agents are required to treat you impartially and objectively. And an important aspect of designated representation is that it reduces the likelihood of multiple representation. You can read more about this in Caution. Multiple representation is not permitted unless you agree on page 9. Designated representation was introduced in Ontario on December 1st, 2023. Ask the real estate agent what type of representation the brokerage offers. What to look for in a representation agreement. Your representation agreement should describe the duties owed to you, the services you will receive, your rights and responsibilities that you will pay. Your representation agreement should describe the duties owed to you, the services you will receive, your rights and responsibilities, what you will pay, and specific terms of the agreement, including how long the agreement will last and whether you can cancel it. Here are some key things to look for. Name of your designated representative. If the contract is a designated representation agreement, the name of your designated representative will be included. More than one real estate agent working at the brokerage can be identified as your designated representative. Scope. Your agreement should specify the scope of the engagement. If you are a seller, this means the agreement will identify the specific property. If you are a buyer, you should consider the scope of the agreement carefully. Your agreement might identify a specific property, a geographic area you are searching in, a type of property you are looking for, or other specific requirements. For example, if you're looking for both a house in a particular city and a cottage property near a lake and want to work with different real estate agents with local and property type expertise for each property, the scope should be clear in each of the agreements to avoid disputes about who you might have to pay if you buy a property. Services. The agreement must clearly set out the services you will receive. There is no standard set of services. Brokerages offer a variety of service options. You choose the services you want that best meet your needs. You might enter into an agreement with the brokerage for a specific purpose. For example, having an agent prepare an offer on a property you want to buy or viewing a specific property. Some sellers enter into agreements solely for the purpose of having their property advertised on a local listing service. Ask the real estate agent about the available services or a combination of services that may be right for you in your situation. If there are specific services you need or expect to receive, make sure they are included in the agreement or as a schedule to the agreement. Don't assume a particular service will be provided if it's not included in the agreement. Payment amount and terms. You and the brokerage decide the amount you will pay for services. The amount is not fixed or approved by RECO, any government authority, or any real estate association or real estate board. You can agree to pay a fixed dollar amount, a percentage of the sale price, or a combination of both. The representation agreement cannot specify an amount based on the difference between a property's listing price and what it sells for. Agreements must also identify circumstances in which the amounts agreed to might change and how they will change in each circumstance. If you are a seller, your agreement needs to clearly indicate the amount you agree to pay your brokerage or how it will be calculated for the services and representations you receive, the amount or how it will be calculated you agree to pay, if any, to compensate the buyer for their brokerage fees, and how the amounts you agree to pay will change if you consent to multiple representation. If you are a buyer, your agreement needs to clearly indicate the amount you agree to pay your brokerage or how it will be calculated for the services and representations you receive, how the amount you agree to pay will change if the seller agrees to cover some or all of your brokerage fees, and how the amount you agree to pay will change if you consent to multiple representation. An important note for buyers, a seller might not offer any amount to cover the fees you owe to your brokerage under your agreement. This could affect the amount you are able to offer for a property. Depending on your financial circumstances, you may not be able to afford to buy a property when the seller does not agree to pay your brokerage fee. Termination provision. The agreement should list all circumstances when the agreement can be terminated, review when the brokerage can terminate the agreement, and make sure you're aware of any penalties or costs that might apply in each case. Two important circumstances to be aware of. Multiple representation. You do not have to agree to multiple representation, and your agreement should be clear about what happens in that situation. So for example, the agreement could terminate completely, or you might be referred to another brokerage or designated representative for the specific transaction, but otherwise remain under the agreement with the brokerage. Changing your designated representative. If you have entered into a designated representation agreement, the brokerage could not appoint a different designated representative unless you agree. The brokerage may ask to appoint someone else if, for example, your designated representative stops working with the brokerage or is otherwise not available to provide the services and representation outlined in the agreement. Expiry date. The agreement's expiry date must appear prominently on the first page. There's no set time or standard term for a representation agreement. It could be in place for a day, a few weeks, or months. Consider how long you want the agreement to remain in place and make sure you know when your agreement will expire. Keep in mind that a holdover clause could mean you owe money even after the expiry of the agreement. Holdover clause. Most representation agreements include what is often called a holdover clause. The clause may require you to pay the brokerage fees for a purchase or sale even when the transaction happens after your representation agreement expires. The clause will specify the time the holdover clause in effect from the date the agreement expired. For example, let's say you are a seller and your agreement includes a 30-day holdover clause. This means that even if your agreement has expired, under certain conditions, you might be obligated to pay the brokerage commission if you sell your home during the 30-day holdover period. Similarly, if you are a buyer and your agreement includes a 30-day holdover clause, you might be obligated to pay the brokerage commission if you buy a home during the 30-day period that the agent showed you before your agreement expired. The holdover clause is designed to protect the brokerage, and there is no minimum or set time for a holdover period. If your agreement includes a holdover clause, make sure you agree to the length of the holdover period before you sign it. Caution: multiple representation is not permitted unless you agree. Multiple representation means a designated representative or brokerage represents more than one client with competing interests in the same transaction. This can happen in different ways depending on the type of representation you and the other clients have with the brokerage. Brokerage representation. Multiple representation exists when the brokerage represents both the buyer and seller in the same transaction, or two or more competing buyers interested in the same property, even when the clients are working with different real estate agents. Designated representation. Multiple representation exists when the same real estate agent is the designated representative for both the buyer and the seller in the same transaction, or for two or more competing buyers interested in the same property. Multiple representation is not permitted unless each of the clients involved agrees. You should seek independent professional advice before proceeding. If you agree to multiple representation, the brokerage or designated representative cannot fulfill their duty of loyalty to you, cannot promote and protect your best interests, must treat each of the clients involved in an objective and impartial manner, and cannot offer advice to you, including the price you should offer or accept, or terms that should be included in an agreement of purchase and sale. Confidential information you provided to the brokerage or the designated representative when you were represented cannot be shared without your written consent. The brokerage or your designated representative has a duty to promote and protect your best interests and avoid conflicts of interest. It is expected that brokerages and real estate agents will not knowingly enter into an agreement that will compromise your interests, meaning you will no longer benefit from the promotion and protection of your best interests in the transaction. What to expect before you agree to multiple representation. The brokerage is required to provide you with a written disclosure that explains how the brokerage duties and designated representative's duties to you will change, the differences in the services you will receive, and any change to how much you pay the brokerage. Until this information is disclosed in writing to all clients in the transaction, and they all agree in writing, the brokerage or designated representative cannot take any further steps on behalf of any of the client. You can refuse multiple representation. If you don't agree, the brokerage or your designated representative is not allowed to proceed. Ask the brokerage or real estate agent about alternatives to multiple representation. For example, if you are a buyer, the brokerage could refer you to another brokerage or another designated representative to help you make an offer on the property. Some people believe that multiple representation can give them a better deal or reduce the brokerage fees they have to pay. Agreeing to multiple representation significantly reduces what the brokerage and its agents can do for you and means they cannot look after your best interests anymore, which can lead to other consequences and costs. Content of other offers. You may have seen articles in the media about open bidding or an open offer process. Buyers in Ontario who have made an offer on a property are entitled to know the number of competing offers. Sellers choose how much other information, if any, they want to share about the offers they receive. If you are a seller, you decide how much information you want to share about the competing offers. Your agent will advise you based on the characteristics of your property, market conditions, the content of the offers you receive, and other things. You need to provide clear written direction to your agent before the content of any offers can be shared. Personal or identifying information contained in offers cannot be shared. If you are a buyer, you decide whether you want to participate in a process where the content of your offer might be shared with other buyers. Your agent can tell you the steps steps to take to avoid having the content of your offer shared with other buyers. Be aware that the seller can make the decision to share the content of other offers at any time. You may not know in advance. How to make a complaint. Brokerage firms and real estate agents working in Ontario must be registered with RECO. Ontario brokerages and real estate agents are accountable for their conduct. If you have a concern, first contact your brokerage. In many cases, your brokerage will be able to mediate or resolve your complaint about a real estate agent or the services provided under your representation agreement. Search for the brokerage in RECO's public register to find the name of the broker of record, the person responsible for ensuring the brokerage complies with the law, and their contact information. Know that the brokerage cannot ask you to sign an agreement that requires you to withdraw a complaint to RECO or prevents you from making one. Contact RECO to file a complaint with RECO about a brokerage or real estate agent. Visit the complaints section of the RECO website. The website explains the complaints process, possible outcomes, and how to file your complaint. RECO will review the issue, determine if it has authority to deal with it, and what the next steps, if any, will take. This is RECO's office on Bloor Street in Toronto and their phone number. You can find all those details on reco.on.ca. You can also find more information on the website about buying and selling the property in Ontario and for the legislation that governs brokerages, real estate agents trading in real estate in Ontario, Trust in Real Estate Services Act of 2002. The last page is the acknowledgement, which states the real estate agent's name, the brokerage's name, and that this guide has been provided to either the buyer or seller. If you found that guide informational, it is important that you've received one of these guides either digitally or in person, and this is something that will be included in all packages for buyers, sellers, landlords, and tenants moving forward. If you ever want to connect and have any questions about this guide, you can book a call with me in the first link in the description down below. I'm Michael Ouzas. Thanks for watching.